Defamation. The action or crime of making false statements damaging to a person's reputation. Part 1. New York Times Company versus Sullivan, 1964. L.B. Sullivan, the respondent in this case, sued the New York Times newspaper for libellous statements about himself and his work. Sullivan testified that he was Commissioner of Public Affairs, and the duties are supervision of the Police Department, Fire Department, Department of Cemetery, and Department of Scales. Sullivan believes that the New York Times sullied his name with non-factual accusations. It was printed that the police department biasly attacked important individuals of the civil rights movement. This all led to a monumental case. According to Sullivan, his reputation was damaged by the New York Times publication. He was now being seen as an enemy to the civil rights movement. But according to court record, it was pointed out that is very unlikely. Viewed realistically, this record lends support to an inference that instead of being damaged, Commissioner Sullivan's political, social, and financial prestige has likely been enhanced by the Times publication. The plaintiff must show that the defendant has been harmed, emotionally or physically, by the false statements printed. For example, Sullivan felt that he was being seen as an enemy, even though he controlled many of the city's organizations that kept him safe. This puts him in a bad light and opens him up for unwarranted retaliation. The United States Supreme Court ruled in favor of the New York Times Company. The court ruled in this way because they felt that there was no actual malice, the desire or intention to do wrong. Their freedom of speech was practiced and then protected. Sullivan did not sustain any actual damage from the printing because it never mentions him by name. Part 2. Welch versus Gertz. The parties of this case includes Welch, a magazine publisher, and Gertz, an attorney. According to the case file, Gertz was considered to be a private person. Neither petitioner's past service on certain city committees nor his appearance as an attorney at the coroner's inquest into the death of a murder victim made him a public official. Some of the alleged defamatory statements that were published called Gertz an architect of a frame-up, a Leninist, and a communist fronter. All these statements are considered to be libel against Gertz. These outrageous allegations were proven wrong when looking into his history. Gertz was never arrested, has never had any history being a part of any communist organizations, and was not involved with attacks on police during the 1968 Democratic Convention. These allegations definitely affected Gertz's reputation. He claimed that the falsehoods published by respondents injured his reputation as a lawyer and a citizen. To be called a communist, Leninist, and be accused of attacking police sullied his career and personal life. If I was Welch and I felt the need to bring down Attorney Gertz, I will have done the proper research into his personal life while abiding the First Amendment. Throwing out random allegations against a private person based on little to no evidence will destroy my own reputation. The elements to defamation claim in New York State are as follows. 1. False statement. 2. Published to a third party without privilege or authorization. 3. With fault amounting to at least negligence. 4. That cause special harm or defamation per se. While examining both the Sullivan and Gertz cases, I began to understand the application of the freedom of speech. Of course, we have the right to free speech, but it comes with consequences. When you're speaking about a private person or a public figure, it is important to be truthful. Even when you are truthful, you must make sure you are following the law and how to obtain those truths or other information. Making sure you are granted the permission to share the information is another big piece to the puzzle of public speaking and representation. Thanks for watching.